So just to describe to the audience what occurred, we were overjoyed with the response to this invitation to the roundtable. And so it's bigger than I had anticipated. That's the discussion of the Republican primary discussion. That is, it looks a little bit unwieldy. So in order to that, with thanks to all the participants agreeing to this, we will actually try to adhere to time limits and that kind of thing, and hopefully avoid what happened to the moderator in the last debate, the Republican debate. So I will try not to intrude too much. But before they all came here, I gave them 10 lines of inquiry, or 10 separate types of questions, and asked for volunteers. Based on those responses, I'm going to be directing the questions to the initial folks who said they really wanted to talk about that. They will have that initial 5-minute or so to present, and then anyone else who really must intrude on that conversation can lift up their little card, and I will give them 2 minutes to comment on that. And then also just to remind the folks out there, if anything strikes you as worthy of questions, the students are here with index cards. Just raise your hand during the course of it. They will come, write down your question, either directed at the panel as a whole or particular folks, and I will insert them into my own index cards so that we can proceed with a rather smooth conversation. So based on that, the first questions were about judgments of success and failure. And the question was something along these lines. Given all the unresolved challenges, and I think you've heard them from some of the commentators, continued intra-state conflicts, climate change, refugees, displaced persons, income inequality, arms proliferation, and so forth, has the UN actually succeeded in advancing the rule of law? And what, in your view, has been the UN's most important legal contribution and its most important legal failing? We'll start right over here with Professor Appiah.
We'll see whether I manage to fill 5 minutes. I think I want to draw an analogy between the role of the Universal Rights Declaration and the American Declaration of Independence in the following sense, that I think that one of the big impacts in the period since the creation of the United Nations of its existence has been twofold. One is to articulate a bunch of values as legal values, to suggest that, and this has had a big impact, for example, in all the constitution making that went on in the decades of independence, in the decade of independences, beginning with the independence of Ghana in 1957, where I grew up. The idea that these norms should be embodied in national law, that they should be shared across the world because they were norms, they were universal in that sense, did have some impact. And so many of the rights that are now exercisable by citizens against their states derive some of their historical force from the fact that they were enunciated, not as law, but as declaration, early in the founding of the UN. And I think, the Declaration of Independence is not a legal document. It doesn't have any legal force, but it enunciated a bunch of principles, some of which were then embodied in American constitution making and then in the Bill of Rights and so on. And I think that that's a very important contribution. Again, I think, as Professor Simmons said, we have to ask about the right counterfactual. It doesn't follow from the fact that these ideas have been widely circulated that they've been implemented, but are we better off with them having been articulated and put in place than we would be without them? I think the answer to that question, in my view, is certainly yes. So that's a very important contribution. And then, of course, within the system itself, the other great contribution is that the UN has generated a very powerful set of mechanisms for creating international law, for giving legal content to the aspirations of all kinds of people in all kinds of dimensions. Now, again, the fact that these international treaties are often, to use a rather odd phrase whose etymology I can't recall, honored in the breach, that is to say, we articulate them and then we don't take notice of them, doesn't mean that it isn't important that they've been articulated as legal ideas, because, again, to pick up a point of Professor Simmons's, This sort of massive change in the world takes time, and you've got to lay down the tracks. You can't implement something if you haven't even laid down the tracks. And I do think that it's really important. So those two contributions, I think, articulating universal ideas that have then actually been nationalized in lots of places, implemented locally, and creating just the basic of the idea that there are mechanisms for creating international law, and whether we breach it or not, they're very important sources of legality, and as we move forward, we will have these mechanisms in place in order to make that happen.
Okay, so I have little secret follow-ups from this, and that was very positive. So I'd like to hear a negative, and Pablo de Grief, you are one of the mechanisms created by the UN. Can we have a negative on a perspective on what the UN has accomplished? And then Rita, you'll get a third crack at this.
I will actually be disappointed by providing yet another positive in the following sense. Yes, Jose, I'm very sorry. Because I agree that if we hadn't created the UN in exactly the same way that we have, something like this would be necessary. I had never done any work for the UN, and I'm not a UN staff member, but my experience with the institution as an external expert is that a lot of this functionality depends on deliberate decisions on the part of member states. Of course, this is not to exempt the institution from its own difficulties, but I want to make the following point as well. One of the ways in which the UN is useful is that it is a very, very useful scapegoat. That without the UN, lots of bilateral, very, very fractious relationships would play themselves out face to face without a third party to blame, and would demand a type of resolution that would in fact put much more pressure on bilateral and multilateral relations. So I don't think that we ought to be completely negative about the role of an international institution, even when it is of moderate effectiveness in direct, measurable terms. And again, I'm sorry to disappoint you for
So Rita, would you agree that one of the best things the UN has, it has like a kick me sign on the back of it?
Yes, and I'm sorry to disappoint you, but I will try to point also some positive aspects.
Anyone with a negative, please
But I have
hold
a
up the
negative.
card.
But I also have a negative. Okay, so first, I think it is important that we have a common legal framework and institutions that the UN has created or that evolve around the UN, like the ICJ, the ICC, and other, also the plethora of multilateral treaties that the UN has created and enabled us, states in this case, to function. That is also very important. On the negative side, as I promised, I would think it's not so much legal, but it's more political, which has to do, of course, with the functioning of the Security Council, of the situation of the veto, as I promised my English colleague that I would speak badly about the, the P5, and I want to keep my promise. So that is, I would say, what we can see one of the failures of the UN, the difficulty to have the Security Council operating sometimes in a more, I failed the term, not to be, but in a more coherent and decisive way.
Would you like to respond, Mr. McGlann?
Sorry, it's on.
A defense of the veto would be fine.
Yeah. Well, I think the best defense of the veto came from the earlier speaker. Look, there is a phrase in English that if you were going to, I better say Edinburgh rather than Dublin, you wouldn't start from here. And I think the veto.
Could you speak closer to the mic?
The veto on the system that the UN enshrined in the UN at the moment is what it is because it's a creature of history. The problems I think are not inherent in the structures, but in the politics that underlie the structures. And given that these politics exist, it's quite difficult for me to see how you could create a regime which would not involve some kind of veto with powers like, let's say, the US, China, and Russia around. I mean, is it really conceivable, and what would be the point of having a system which could vote a binding resolution on these countries, on issues like the use of force?
Can you foresee any circumstances of some kind of political agreement like the one that France has proposed, where at least as politically you would agree not to exercise the veto in certain cases? Is that feasible?
There was a French one. There's another one, I think, proposed by Liechtenstein the other week, which the UK has signed up to too. So I think politically it's feasible, but it's the same question. What is the politics of it? And I think it's probably easy to demonize the politics of Russia and China in these issues. I think one has to also try and see things from their point of view. What do they see when they look at the world, and what do they see as they look at the UN and as they look at the global politics, particularly around the US, but also the way the world has gone in the last 40, 50 years. But again, I come back to the question. You know, as a government lawyer, I do have to deal with what is called the art of the possible, and I think that's a very, very fine phrase. Every aspect of that phrase gets exactly the difficulties we have on a daily basis. But if there's to be something different, what's it to be, and how's it going to work? So, I think it is what it is. It works in many ways, as has been pointed out, and I think there's a lot more one could say positively. I could talk about a lot more about the positives of the UN system, and even the Security Council. But I think that one is really tough. But equally, you have to recognise that it's at the very tough end of the spectrum. There are murders and there are killings in every society represented here. That doesn't mean that the rule of law is broken down in these societies.
Anyone else want to comment on that question? Mr. Talley.
I don't so much want to comment. If I may, I would like to ask Ian a question. I was intrigued by the defense of the veto. I don't want to turn this into a veto discussion. I certainly agree with Ian that we have the veto and it is what it is, and I don't see politically a possibility of changing that in any form, whether we're talking about institutionally in terms of an amendment of the charter, or even in terms of a political agreement that it will not be used. I don't see that as a political possibility. And so in that respect, I very much agree with Ian that it is what it is. What I'm not so sure about, though, is the comment that it serves a purpose and that you know, I mean, if we could envision the world differently, if we could envision the charter differently, that you seem to be suggesting that it would still be a good idea to have the veto. And I'm not sure in what sense or what good comes out of the veto. I can certainly see that not having the veto is not going to solve all the problems, but it certainly would make it a lot easier to come to decisions on some aspects, at least, that states aren't able to come to a conclusion on now. So I'd be very interested to hear in what sense it contributes to a sort of more cooperative, more peaceful world, maybe, I don't know.
I think there is an analogy, I think, with I'm from the Europe, the region, the EU region, and I think there are lessons to be learned from that. The norm now in EU decision making on most areas of policy making, and it's a vast range of policy making, is a majority vote. But that wasn't always the case. It took probably 30 years of the EU as the European communities, as the member states of the European communities working together, getting to know each other and getting to understand each other, before you were able to make the step change internally in the mid-1980s towards a majority voting process. But even then, that still didn't extend to the really difficult political issues around that core. It worked on many of the issues, but it didn't work on foreign policy, it didn't work on justice. So I think getting beyond consensus is essentially the rule there still. So getting beyond consensus into a voting situation represents, I think, a huge development of international policies and international dynamics. So I think you're not going to get there. That's really what I meant, that you wouldn't have, it's difficult to see a situation operating in which a majority vote could take place on issues like the use of force at the UN level. Now, so you're asking me a slightly different question. Is the veto still useful? I would answer it in at least one way, is that without something like it, you won't have a body that is effectively capable at all of operating in that area. And the Security Council has operated on many issues, peacekeeping being one. But I think without having the possibility of people stopping the discussion and keeping the discussion under control from the point of view of these big states, then I don't think you would have any discussion at all.
So let's proceed to a second question. So one is the progressive development and codification of international law is built into the Charter. We have created, for example, the International Law Commission for this purpose. And we have at least two folks that have served on the International Law Commission. So I turn to you. Has it been a success, the progressive development and codification? And I guess part of the question is it a then and before question? That is, the ILC did a lot of treaties once upon a time. Now it seems to have only one on its agenda. It does a lot of guidelines, articles. I once asked an ILC member what the difference was, by the way, between articles and guidelines and mere studies, and there was no real response. So I'm not sure you guys know what you're doing, but are you doing a good job of progressively developing and codifying international law? And I'll start with Mr. Nolte.
In 1949, Herr Schlauterbach formulated a program for the ILC, and he suggested that the program regarding the codification of international law should be finished by the ILC within 20 years. That didn't work out. Still, the 1960s were considered to be the golden age of the ILC when it elaborated the Vienna Convention on the Law of Treaties. The ILC has elaborated a number of texts with which we all work, including in the past decade or so. I only mentioned the articles on state responsibility. The ILC is the repository of general international law, and the question is, can it still fulfill its original idea? I'm not saying mandate, its original idea. And my answer would be yes. The original idea was perhaps more traditionally the idea of codification as it developed in the 19th century in Europe, that you would have a code, some program, some clear rules. And there are areas which lend themselves to this kind of codification. But while certain areas have been codified, it is difficult. Once the flexible customary international law is codified, it is difficult to change it again. Now, how do you keep up the idea and the function of a codification to provide orientation after one generation or more? Take the Vienna Convention on the Law of Treaties. We're not conceiving changing the Vienna Convention on the Law of Treaties, but nevertheless there are certain aspects of it which we want to reassure ourselves about, whether they are still fresh and meaningful, and how else would we make it clear to ourselves that they are meaningful, and in what sense. I think in a group, an institution like the ILC, which does not purport to draft a new treaty, which would then only have few ratifications and which would make us all even more doubtful whether the Vienna Convention on the Law of Treaties would still be good law. That would not be the right way to proceed. It is, I think, the original idea of codification and progressive development, that the ILC does not only have the job of proposing new treaties like a convention on crimes against humanity, but also of nurturing and cultivating the old treaties by commenting upon them, reaffirming them, providing orientation in the light of the practice under them. And in that respect, and that explains why we now have turned to conclusions, and however it is called, I concede that the terminology is not always coherent, but I think one could give an explanation for every one of the different products, but this is not the place. Thank you.
Did you want to comment on the ILC and codification?
I could.
Go ahead.
In just a few words. I share much of what Georg has said. I know that there is in many quarters a yearning for the old days, the golden age as it is. I think what's important is that the ILC makes the contribution that is necessary that the international community needs rather than yearning for what the ILC used to do. And I think what Georg has described in terms of much of the work, much of the current work of the ILC is exactly in that direction. Nonetheless, it would be very abnormal if I didn't disagree, at least in one aspect, with Georg. So I'm not so much going to disagree, but I'm going to say that there is a slight danger that we have to be cautious of, particularly when we go back to treaties and we sort of say we want to give, reimagine them, if you like, or reinterpret them, give meaning to them in light of the changes. Here there's a real possibility, a real danger, I think, that the ILC assumes for itself the place of lawmaker, in a sense, because if you interpret sufficiently, particularly in the context where you draft conclusions which are not really going to be subject to state reconsideration. The ILC could essentially reinterpret and re-envision various aspects of the Vienna Convention on the Law of Treaties in such a way as to take the state out of the lawmaking process. And that is one aspect of the ILC's work currently that I'm slightly concerned with.
Ms. Listad, you had your placard up. Lisbeth?
Thank you. Well, in the presence of so many august members of the ILC, I think...
Get closer to the mic, just if you could.
There are, I think, some issues that will require some reflection with respect to the future role of the ILC. Its mandate is codification and progressive development, and as you said, Professor Alvarez, we seem to have drifted away from the major treaties. I think the ILC has had an impressive role in terms of refining the general architecture of contemporary international law. That sounds very grand, but I do think they've been engaged in a number of quite crucial, in the development of crucial treaties. I think that the major work on codification more or less is exhausted, and that it appears as though the ILC sort of drifted to the middle, which is an area that I would generally describe as clarification, which is not in the original mandate. The original mandate has two poles, and I do think that many of the issues that are on the agenda now are more or less in the field of clarification. For instance, all these interesting subjects in the field of the law of treaties, they are sort of clarifications and working on that, where I think on the one hand side, it is very useful that we have a body of independent experts who voluntarily commit their time to reflect on these issues, whereas us simple government lawyers never have the time to do such profound reflection. We all wished we had, but we never have that time. At the same time, I also think there is unclarity with respect to issues such as who sets the agenda. Not everything that the ILC puts on the agenda is necessarily what government lawyers would want to see on the agenda. Now, you could say that's the price to pay when you have an independent expert body, so they figure out what their agenda is and do some wonderful work on it. At the same time, it is a body that has great authority. So there is a responsibility there. My general comment is that I do think that in the near future, it's important to reflect important for the ILC members and the states to jointly reflect on, well, what's the future of the ILC? Has it, dare I say it, has it more or less come to the end of its work? Presumably that is nearing when you look at codification. I'm not sure if states would altogether think that progressive development necessarily lies in the hands of the ILC. It takes place here, there, and everywhere, in the GA, in specialized organizations. Or is it so that a future role of the ILC lies more or less in the field of clarification with respect to specific and perhaps sometimes quite detailed questions in areas where they have worked before?
It's generated lots of comments, so keep them crisp. Mr. Mohammed.
Thank you, Professor Barris. I would like to comment on the issue on ILC. And as you must know that our organization, the Asian African Legal Consultative Organization, is one of the consumer of ILC. We have a long standing relationship with ILC that we keep monitoring and we observe, and also we give our comments on the topic highlighted or taken by ILC. And I see this is a very important relationship between ALCO, the Asian African Legal Consultative Organization. I cannot imagine that if our organization is not present in the yearly annual meeting with ILC, that many of the issues that has not been resolved or not taken up by member states of the UN, then we would be the organization that carry those issues or concerns to ILC. So at many times, ILC has always asked us, what are the new topics that you could give us or provide us so that we can move on into this new area of international law. And we had that discussion every year, and I've been attending the discussion every year, and I see that this is a very important connection between the Asia-Africa group and ILC. So I don't think that it is a waste of time. In fact, there are a lot of clarification that need to be made. One issue, for example, now we have this current standing of customary international law. Now we argued, the Asia-Africa countries argued that they have been deprived being participants of lawmaking, especially on international law for the past 300 years. So I thought this is the best opportunity for organizations like Asian and African legal consultative organizations participate and provide a meaningful and useful content or rather feedback to this organization. I don't think that it is not wasteful at all. Of course, we agree that there are perhaps new topics that could be taken up by ILC. But you know, the other important issue that I can understand members of ILC is grappling or trying to understand is whether they have the political will to push sensitive issues on international law to bring forth and to later be accepted by. It is the member state that eventually will take up the issues at the General Assembly. Thank you.
Judge Sepulveda, and then we'll come around to your response to.
Thank you, Professor Alvarez. The issue perhaps is who is responsible for codifying what. Perhaps in the 50s, the 60s, even the 70s, the ILC was the one who was mainly in charge of codifying law. And the ILC made a very important contribution. For example, law of the sea, treaties, immunities, diplomatic and consular relations. But then somehow the responsibility has been transferred more directly to the states. The main example would be the case of the law of the sea. I mean, the 58 conventions and the 1960 convention were a very important contribution to the codification and development of international law. However, in the 70s, things changed, and the states themselves decided to negotiate a new treaty on the law of the sea with no role assigned to the International Law Commission. The same is true, perhaps, in the case of the Statute of Rome, where originally there was a draft on the part of the ILC, but then the Statute of Rome developed a different concept altogether, and perhaps a more ambitious one. One other point, the draft articles on state responsibility. When I was a member of the ILC, I was strongly advocating in favor of having a treaty. I failed, and perhaps for very good reasons. It was said that probably very, very few states would sign and ratify a treaty on state responsibility. Now, what has happened is something very interesting. The fact is that from those draft articles, perhaps what we have is a sort of customary law by which courts and tribunals, and of course the International Court of Justice is part of that, but it's not the only one, because we have the ICTY, and we have also arbitral tribunals getting into the sphere of state responsibility and getting those drafts as part of the source of the decisions they take. So things have changed, and we have to accept that fact. Thank you.
Maria?
Yes, thank you. Well, I just wanted to react to what was said earlier about who sets up the agenda of the ILC. And here we should make a distinction between codification functions and progressive development of international law. I think it's obvious that, and it is also written in the statute, that progressive development should be set by states. And it's obvious in the Sixth Committee we have this kind of discussions. Of course, it's difficult to say which rules fall under the ambit of progressive developments and which are under codification functions. But of course, for the ILC, it's easy to say that. Sometimes this distinction is blurred. But I want to say that I cannot find any other more appropriate body to do the function of the progressive development of international law than the ILC itself. This is obvious. Right now, in the General Assembly, there is a discussion about universal jurisdiction. And actually, there are states who have refused to confer this to the ILC, insisting that the Sixth Committee is the most appropriate body to hold this kind of discussion. Well, I won't express my country's position on that, but I think this is wrong. This is an area of progressive development, and actually the ILC is the most competent body in order to start elaborating rules concerning universal jurisdiction. Well, another problem in the Sixth Committee right now is the work of the ILC on immunities of state officials. This is a very delicate, sensitive, politically sensitive issue, and the ILC will have in the future great problems in codifying some rules, especially when it comes to exceptions to immunity. That is an issue that is open for discussion, and I really don't know how the ILC will treat it. But in any way, I think this question should still remain in the hands of the ILC. And despite the exhaustion of the codification process and also standard setting, I think the ILC has still much work to do in these areas. Thank you.
So in order, I think it was Mr. Clavers, Professor Clavers, do you want to comment on?
Not particularly on this, but I'd like to broaden the discussion if that's
Sure,
possible.
go ahead.
Because with all due respect to the ILC, and I have a lot of respect for the ILC, don't get me wrong, it's not the only place in the UN system where law is being made, and I think at least some attention should be paid also to the norm entrepreneurship, if you allow that phrase, stemming from, for instance, the Security Council, which has broadened the notion of security dramatically since 1945. nowadays counts things such as environmental degradation, refugee flows, etc., as threats to the peace in a way that in 1945 would be completely unthinkable. So that's one way also in which the law changes, adapts, etc. The other is the role, for instance, of special rapporteurs. One example I have in mind is one of the former special rapporteurs on torture, who boldly proclaimed domestic abuse to be fitting within the definition of torture. Now that's lawmaking in a different way as well. So the ILC plays an important role, but there's more to lawmaking than just the ILC. That's all I was hoping to say.
So Phoebe, and then we'll turn to Nolte.
Okay. Mine's slightly different, but as a lifelong user of the ILC, of course, I've been very grateful to the codification work done by the Commission generally, but also by the individual reports of its members. But I did wonder whether some of the later reports have this kind of scratching at the bottom of the barrel. But my more immediate concern really is in terms of representation, that all the UN bodies, it remains one of the least representative in gender terms, and that has continued to do so. And also the processes by which members themselves select those who represent them within the International Law Commission. There is a perception within the Commission itself that the burden of the Commission is distributed unevenly, partly because of who member states send to the Commission and their commitment to the Commission's work. So in part, there are those who feel that the regions where they come from are not effectively represented in the Commission's work. But it's a double-edged sword. If you send those not committed to the Commission's work, well, then you get what you ask for. And so I just do wonder whether there's a debate about opening up the processes by which states nominate people to the Commission, whether they can address the question of gender, lack of gender representation within the Commission, and how we move things forward, because this has been going on for a very long time.
Ian?
This discussion is between an overabundance of mics. It really isn't that worth hearing. But anyway, this kind of gets me into the point I was going to mention, which I was very struck that the discussion is all through the prism of states. And indeed, I mean, Deirdre's reaction on Georg's comments was that he was worried about whether the product of the ILC lacked legitimacy because the states weren't commenting on it. And I entirely understand the point he's making. But it does raise the question of what other entities and organs and mechanisms are out there which are developing international rules or contributing to the development of international rules. And Jan mentioned a couple, but I had more in mind the kind of things that you mentioned, in fact, in the question. Non-state actors, you mentioned 2 or 3 of them, but I think that's a really interesting issue. I mean, how they contribute to both the work of the ILC, because I agree, I don't think it is representative enough, and I don't think it's representative enough either in gender terms or in terms of diversity of thought, if you can put it that way. There's only one kind of thought coming through that. But if you look into the broader context of international law, where have some of the really big and interesting developments come? They've come not necessarily only at the behest of the NGOs and the non-state actors, but certainly with a huge push from them. Climate change, discrimination against women, the rights of children, the ICC. These are the new big areas, big different areas, and the challenge and the drive and the impetus has come from outside the state system. Now that may get us into question 4, which about the whole gender issue, but at least the bigger issues there are, if we talk about states only, we're losing an awful lot of what's going on out there.
So I'll turn back to Professor Nolte and Talde, but I guess you're the head of the group studying subsequent practice, and I think what Professor Klabbers was talking about was subsequent practice within the UN as actually developing the law considerably. And how should we think about the subsequent practice in terms of, say, special rapporteurs' reports, or things that are not the core organs of the UN, but are certainly reported back to the UN, states react to them? How should we think about that?
Well, I could not agree more with Jan Klabbers. The ILC should not have a monopoly. I mean, it never had a monopoly of progressive development and codification of international law, and we should celebrate that there are many fora. And the question is, what is the proper function of the ILC. So in a sense, our discussion took a wrong focus for a while by concentrating so much on the ILC. But I think it is we should not turn to the other extreme and say, well, the ILC is not as central anymore as it was. Topics are exhausted, and what it's doing doesn't make very much sense anymore. I tend to disagree with the assertion that the topics are exhausted. There are lots of topics around, including those which were part of the original program. Jurisdiction, for example, is, and here we have universal jurisdiction, is a classical topic, unresolved. And why is it not on the agenda of the ILC? Well, perhaps because the ILC, as states themselves, are skeptical about the possibility of achieving a treaty. And then, if it is not possible to achieve a treaty, then the question is, should the ILC get into the business? One possibility would be, okay, the ILC should try, propose a treaty, engage in progressive development. That's, of course, a possibility. And that's the function of the ILC, but debates between states and the Commission so far have led to the conclusion that the topic is not ripe. Another possibility, of course, and that is something which we are seeing with respect to several topics, is that the ILC, not proposing a treaty, formulating draft conclusions or something, formulates a text which is not very clear about its legal status. And the ILC has to be aware that its products are not only viewed and analyzed and worked with by states, but are also taken into account by courts. Right. And I'm speaking of national courts. Now, a national court cannot so easily determine whether a text by the ILC is an articulation of existing law, which they should apply according to their national law, which says you have to apply customary international law, or whether this is just a proposal to conclude a treaty. I think there the ILC has a responsibility to be transparent about what it says and with what authority it says. The draft articles on state responsibility are fine because they say in their commentaries, these are the cases and this is the state practice on which it is based. And the implication is this is an articulation of customary international law. But not everything that the ILC is considering desirable is customary international law. And in that respect, I completely agree with Maria Telalyan that the ILC has the function of progressively developing the law, by the way, also of proposing a codification, but it should be clear about what it is doing, and that it is, it may not itself develop the law. It may propose development of the law by states. And that distinction should be maintained. May I say just a short word with respect to the question of agenda setting? I think we should be careful not to engage in a different form of mutual blame game here. The ILC, as Mr. Mohammed has said, has often asked states to tell it what they should deal with. And then when no proposals came, it came itself with proposals which were debated in the Sixth Committee and which were greeted and which were accepted. So I think there is no false unilateralism here.
Okay. So you want to say a quick word? I don't want to spend too much time. Mr. Daldy.
Yeah. So I had just a couple of comments. The one comment is the last one that Georg just made with respect to the agenda, so I won't make that comment. And then my second comment relates to the point that Elizabeth made about the ILC's role in clarification and how that's not really part of the mandate of the ILC. And I thought it was very interesting that in certain aspects or in certain respects, there is a tendency to sort of interpret the Charter narrowly to exclude certain things that aren't explicitly written in, while in certain aspects we are quite happy to sort of have a broad interpretation that takes into account the new context of the international community, like, for example, with respect to the mandate of the Security Council that we discussed earlier. And then my last comment relates to the point that Georg has made with respect to the distinction between codification and progressive development and how we have to be very cautious. And I think that's right that we have to be cautious. But again, I think we have to be cautious in how we make that distinction. There has been I shouldn't say a tendency, it was particularly expressed in the last sort of draft articles that were adopted, where very specific provisions were identified and defined as codification, progressive development. And I think that I find to be dangerous, because in fact what it does is it has the effect of preventing the progressive development by saying to the world, we have already made the conclusion that this is not law and you can ignore it. So I think we also have to be cautious about how we make the distinction between progressive development and codification.
So I don't want to dwell too much on this, but there was one question that I had in the materials that had generated some interest, and I want to put it out there. And the question was, it's sometimes said that international law is a tool devised by the West, imposed on the rest, and that includes progressive development and codification. And several of you volunteered to speak on that point, so I will turn to Michelle Walker as one of the volunteers. Would you like to say a word on that?
Right. Essentially, we had noted that the idea behind that the international law is a tool for the West can only be described as relevant for a particular period in history, and that time has long since passed. With the advent of the Charter and the waves of decolonization, many states, many small states, many developing states gained independence and have contributed significantly to the development of international law. Their examples abound. The UN Convention on the Law of the Sea, the ICC chart, the Rome Statute on the International Criminal Court. I think many of us forget that the idea for the court originated with the Republic of Trinidad and Tobago. Issues such as climate change, environmental issues, many of these are pushed by developing countries. They have all contributed. So international law as it exists now is an amalgamation of developed countries and developing. We all play a role. How it continues to develop is also, it will be an amalgamation. There are challenges that developing countries face, which is something that we continue to deal with and want the opportunity to articulate further. But I don't think reasonably and rationally at this point we can assert that it is a tool from the West any longer.
Mr. Kat, would you like to address this?
Thank you. I agree very much with what Michelle has said. I think today you still find that the developed nations and the Western powers have an overwhelming ability to influence the agenda. But I think it is a function of being earlier in the game, being better developed in terms of the way they educate and equip their people, and also part of the function of the real economic power and political power that they exercise within the world order. But we do see the trend shifting, and with the developing countries becoming more aware of how the system operates, becoming more committed into investing in the education of their people, and pushing more of the international lawyers into positions of influence. We are seeing that the developing states do get a more and more effective role in influencing the agenda. So I do think that there's still a balance in favor of the powerful nations. As we've seen, you have to accept that is inherent in any system. But it is incumbent on the developing states to understand the system and to develop the capability and the ways and means to make their voice heard and to create the space for influence.
So I'll go around. Pablo, would you like to comment on that?
Yeah, I think that this remains an important issue, but I agree largely that it's associated a lot with a question of resources. So let me illustrate. When the Human Rights Commission then was discussing what became the basic principles on remedies and reparations, in one of the last discussions in Geneva, I had a conversation with a delegate from Peru about a narrow, substantive, technical point. And his response was, look, I am the only person that is tracking this discussion. For me, this is one out of 7 topics that are being discussed at the Commission. There's only so much I can do to help you. I was lobbying for a particular interpretation of a point. In the meantime, the State Department, the US State Department, had hired and flown to Geneva 7 full-time lawyers to take part in the discussion. So obviously, I mean, there is a question about the disparity of resources that one cannot be naive enough to say that it's not relevant. On the other hand, it must be said that the US and the UK, for example, that had very strong reservations about including international humanitarian law in that discussion, eventually ended up conceding the point. So resources do not translate automatically into victories either. So the situation is now much more complex. I think it would be a simplification to say that this continues to be the West's playroom. On the other hand, I think it would be naive to say that questions of resources, expertise, are completely neutralized at this point yet.
You had your card up, but also you have a question from the audience. So, so you can address what you wanted, but I'll pose the question. Can the 6th Committee's working procedures be changed to better make states engage in fruitful debate on pertaining legal issues? What would you change in the 6th Committee? Now, that's a deep, UN question. I wouldn't have thought of that.
I wonder why anyone would think I'm the most appropriate person to ask about the 6th Committee working methods. Okay, but while I think about the answer to that, let me just make the comment that I was going to make. And that is that I think that the answer to the questions that have been posed should be in the negative, simply because of the manner in which they are asked. So if you ask, is international law a tool for the West? Is it an imperialist tool? I think certainly the answer to that would be no, but I think what we shouldn't forget, and here I think slightly disagree with you, in the vast majority of discussions, debates, lawmaking, the poorer states do in fact lose. There was a comment earlier about why does the UN Declaration on the Rule of Law not say that the UN itself will be bound by the rule of law. I would just point out that, in fact, that was the position of many states. The NAM states, in fact, held the position that in coming up with this declaration, there should be a focus on the rule of law at the international level, and what that means is that the UN itself should be bound by the rule of law. But I think it is about resources. It's about something else. And here I should be very cautious because I'm going to be speaking to the legal counsel, not so much the legal counsel, but to the legal counsel's office. I mean, we speak about reports of the Secretary General being drafted, but what we often don't know, and I know this from my experience as a delegate at the UN, that very often powerful states are consulted as to what the content of those reports will be. I'm going to share an anecdote without saying who the participants are. I was invited to a dinner once, and it was only big states and me. I don't know why, but it was only big states and me. And I can sometimes be silent. And at this particular dinner, I was rather silent. And I guess my presence was kind of forgotten. And at some point, they had a discussion about the piracy SG's report and how it's sort of the then legal counsel, not you, the then legal counsel who was present at this discussion, how she had a discussion with the legal counselors of two particular missions, and sort of this was negotiated amongst the three of them. That's very important in terms of the influence of lawmaking. And of course, these are things that you cannot point to openly because they happen behind closed doors. But these are the realities, I think, also that influence sort of how law is made. So question from the audience about the Sixth Committee and how it can be revitalized. I mean, this is a question that certainly since my days in the Sixth Committee has been considered. How can we revitalize the Sixth Committee to make sure that the Sixth Committee actively engages in real work rather than the kind of stuff that's happening now? I am sure, I haven't been involved in the universal jurisdiction debate, but I'm sure that if I were to walk into the debate, I'd be able to make the same statement I made 5 years ago and it would be relevant, right? I think that the answer to that question, and again, this is not something that will be popular with many people, is what I find to be at least one debilitating factor for the Sixth Committee is the fact that everything has to be decided by vote. By consensus. So which means that if I don't want progress, so if you take the universal jurisdiction issue, I mean, if there's 1, 2, 3, 4 states that don't want progress, all they have to say is, well, we won't support this. We will call for a vote on this, and that's the end of the discussion. I mean, that's certainly one of the things that you would have to look at if you wanted to revitalize the Sixth Committee. I'm sure there are other things, but I think that's the one thing that has that I found to be particularly problematic in the process.
So one of the cards directed a question to on the Security Council, and I think this is an issue that's come up in some of the other questions. How much is the issue of Security Council reform, especially the question of expanding geographic representation, going to affect the legitimacy of the UN in the future? And I'll just cite that David Malone, for example, just had a conversation here saying, look, if we're still discussing the Security Council reform 20 years from now, the UN will have suffered quite a bit. So I know this is the never-ending question of the never-ending Committee on Security Council reform, but can you address that point? Certainly some of the audience think someone should.
What exactly is the question?
The question is there any, I guess the question is there any prospect? And if there isn't, will that affect the legitimacy of the Security Council in the future?
Well, but am I the best person in the panel to answer this?
No, it was directed at you, but if you don't want to, anyone else.
I can answer the first one's quite easy. You will only get a change if you get the consensus among the P5 in particular, and then the rest at the end. But the P5 have a lock on that. So as to the legitimacy, well, what does everybody think? I mean, has the UN lost legitimacy? I don't see the discussion showing that the UN has lost legitimacy. It shows the opposite, in fact, that there is a phenomenal amount being achieved through the UN as it is. It is, and going back to the question of big states and little states, the thing that in my time in New York struck me was the power of the individual. If you had one person or one state which was interested in an issue, was willing to drive it, there was a huge ability to do that. Not, of course, on trying to solve Syria, but we know the problems of things like Syria and Palestine are just at a different level. But if you're talking getting progress in the ICC, you progress on many other issues, an individual asked with a state willing to let the person get their head, and Dira would probably have been one of them actually. He would have been someone who was perfectly in that category, colleagues from Singapore or others also that I can think of, who are able to take forward an issue and really change the dynamic and make things happen. So the system does work. And I think if one only focuses on the question of the veto and Syria and the rest, then yes, you can conclude that it's all lost. But I don't really see that that's where the UN, the only measure of the UN success. We haven't touched on criminal law at all.
Right.
Very difficult issue. We haven't reached human rights, another one, where the UN has a huge degree of legitimacy. And sorry, one other point. I have been struck again and again in these discussions about just how important law is, even in the Security Council. And in this room, I might just give the example that always comes to mind. The context was just after 9/11, and the discussion was the resolution that became 1373. Now, those of you, anyone who was around the UN at the time knows just what a shocked environment that was. The UN was shocked, the world was shocked. And there was a real willingness to try and help the US. And it's hard to think back to that now, but the feeling that the US had been a victim and an unjustified victim of a terrible thing was very strong. So real willingness to help the US and try and give them what they needed. And they had come forward with this resolution, which was about financing of terrorism, essentially. And they clearly wanted it adopted quickly. One of the last points that held up that resolution in that atmosphere was the difference between ensuring that perpetrators of terrorist acts receive justice, which is what the US text said, or, which is what this one state, and it wasn't one of the big five by any means, it wasn't us, they wanted that changed to, are brought to justice. Now the difference between these, and that's what it finally said, the difference between these two texts is the difference between the Wild West and the rule of law. And in that context, it was still possible to insist on that change. Now, of course, later came Iraq and later came all the rest of it. But still, legality, rule of law, justice were right at the heart of that discussion. And you could multiply examples. Miguel, I'm sure, could multiply examples, as someone is there at the moment, where law and the fact of bindingness is right at the heart of what the Security Council in these big debates is about. And the reason they don't agree things is because they're not willing to be bound. Now you may say, well, they should be willing to be bound, but it's really better to have people who are prepared to sign up to anything but not respect it, or to have people who are not prepared to sign up to things that they're not prepared to implement. That's, in a way, a very powerful example of the rule of law.
Thank you. Rita, did you have a comment on this?
Just very quickly, on the idea that the international law was not a tool devised by the West imposed on the rest. I agree, it is no longer like that, but of course it has a huge impact. The capacity of member states to intervene depends greatly on their capability to have qualified people and to have enough resources. And of course we know that is true, and that is why we see so many times we see the difference. Ian spoke, for instance, of the capacity that one individual has the possibility to intervene and to influence one such discussion. The difficulty is that for some member states, it is very difficult to maintain always that impetus and always that investment in a specific issue, because as you have said, sometimes that same people has to address so many different issues. So at the same time, at this moment, I don't think the difference is between the West and the rest. It's between the dimension of the countries and the capability they have to invest in legal formation and in human resources. And just one quick point to agree on the difficulty to advance things, as in any other international organization, of course, lies on the will of the states. If there is no sufficient will, political will of the states to advance things, that is how it stands. So I agree very much on the idea that the UN has achieved great things, but at the same time, it is still the art of the possible. Thank you.
So it was mentioned international criminal law. We haven't mentioned it, or transitional justice. So one of the questions that I had was, what is the Charter's ground norm today, peace or justice? If both, can we make a coherent narrative out of those competing objectives? And it also connects to the Security Council use of the ICC, and how should we think about it, as a positive, as a negative, either because of selectivity or the conditions imposed on those referrals. And so initially on my list was Phoebe on this and Pablo, so we'll start with Phoebe on this.
Right. With regard, I think following on the discussions that have gone on around the rule of law and also the Charter and peace and security, The Charter had envisaged, or one of the central principles under the Charter of the United Nations was the sovereign equality of states. And implicit in that was that all states would be treated equally and like situations would be treated alike. So that was sort of one of the more foundational principles. And I just did wonder whether, certainly in relation to the Security Council and the International Criminal Court, whether the obsessional engagement, almost obsessional engagement with Africa has done much good to either the Security Council or the International Criminal Court or the rule of law. Partly, as is well known, the Rome Statute itself envisaged that the Security Council would be able to use the criminal court as an instrument of international peace and security by referring cases in the hope that you cannot have peace without justice, and that dealing with those situations in those ways, or some form of criminal accountability, was necessary and essential. But that tool has been used in just one direction. And you may argue, and I think correctly, that the majority of victims are, of course, in Africa. But they are elsewhere too. And one consequence, I thought, of that one-directional obsessional engagement is that it has resulted in alienating both the African Union and, in some cases, the population of the countries who support both the Security Council and the International Criminal Court needs to succeed. In other words, the Security Council, the African Union has called on its members not to cooperate. We know that in countries such as Kenya, where I come from, that was almost treated as a personal referendum in the last elections. And essentially, the majority of the population that had initially supported the court, there was a waning of that public support. So my concern is almost that, I did wonder whether or not this one-directional engagement, in a sense, has damaged both the Security Council, the International Criminal Court, and broadly the agenda of the rule of law, damaging the court itself too, by being seen as an institution pursuing the geopolitical interests of some states, in particular the P5. I think you also wanted me to comment on the Charter's ground norm. And that's the other question, and this follows on, I think, from Beth Simmons' very illuminating talk, that in 1945, there was a very easy consensus that the Charter's priority was peace, and that peace perhaps was to be achieved at the expense of all else, that human rights and other concerns were perhaps peripheral. And so we could have very happy coexistence with dictators, the Mubaraks and the Gaddafis, as long as public order was maintained. It didn't seem to bother too much if these were regimes that were maintaining this order at the expense of the human rights or democratic entitlement of their own citizens. So we could look the other way, even if a government was committing genocide. In that period, since 1945, there has, of course, been a lot of increased public sensitivity to the importance of human rights values, both within states, within the United Nations. And there is almost a feeling that there is a need, or there has been a shift, at least in terms of public perception, that we cannot have this peace at all costs. So you could argue that on one view, the intervention in Libya was a manifestation of this shift from a ground norm, which was peace at all costs, towards more redressing it towards considerations of justice. But then now we have the stalemate in Syria, and to some extent Ukraine. And perhaps I would just repose the question as well by wondering whether, in fact, there's now a clearer narrative, because of course the Charter has spent most of its time trying to chart these competing narratives between peace and justice. And I wonder whether, in light of the stalemate in Syria, we really know where the ground norm or the overriding value within the Charter itself is.
Pablo, would you like to comment?
I agree with a lot of what Phoebe just said, as I will not restate it. Perhaps just to add the following points. with regards to the performance of the ICC, I think that it is fair to say that people who defended the idea thought that the course of the development of the court was going to be slightly different than it has been up to this point. Now, who's to blame for that? Obviously, it's a question that we will not be able to resolve here and that I will not even attempt in a few minutes. But I will just say, I don't think that there's anyone that should feel particularly proud about the way that they have behaved themselves. I think the Security Council referrals, of course, have been complicated cases for a relatively new and inexperienced institution. The self-referrals, even more so, because the self-referrals had a sort of illusory patina of legitimacy and an unproblematic nature, whereas, of course, they were also part of a complicated political game in each of the countries that made those referrals. And I also want to say that the court itself doesn't come out, at least in my view, in a particularly brilliant position, because I think that the Office of the Prosecutor has made efforts, both large and small, quote unquote, for example, with respect to the order of investigations and prosecutions in the Cote d'Ivoirian case. Very, very large mistakes from my standpoint in the case of some of the preliminary examinations, including the Colombian one, and I am Colombian, so I can say this with a particular sense of grievance. So the history, I think, in that case is complicated. Now, having said that, I think that it is easy to trash the court, and that it would be a mistake because, in fact, it is a young institution. There were good reasons to make a bet in favor of an international criminal court, and those reasons, rather than getting weaker, in my mind, have only gotten stronger. So the bet should be how to improve the performance, not just of the court, but of everyone who has affected its performance up to this point. And with Ian, I would like to say that in the discussion about the success and failure of the UN, I think the history of human rights would be an entirely different history without some of the contributions that the UN has made, and that, again, it is easy to downplay the importance, but if we want to make an assessment, here, looking for the right counterfactuals is absolutely essential. And in this domain, I think that the history of the UN will prove itself to be much more positive than its critics would suggest it is. The final point, if I may, is in discussing international criminal law, I think that we should not forget how isolated, institutionally speaking, the ICC is. The analogy with the national criminal courts is, of course, completely inadequate, because in national jurisdictions, criminal courts are actually a fairly minor part of a complicated mechanism of social control that is entirely absent in the international order. We are sometimes, I fear, placing a burden on the International Criminal Court, which its institutional position makes completely unjustified on our part to be harsh on it.
Elizabeth, you're next, and then Rita.
Thank you. Well, to begin with, I would very much like to support what you just said with respect to the ICC and this whole discussion about all the African cases. I don't think there is any element of the rule of law that would suggest that there needs to be a balancing of the cases before the International Criminal Court. The cases before the court are serious cases. I have no view on the procedures, whatever is taking place, but what I can see when I read the website or when I read the newspaper is this is serious stuff, and it has to be brought before a judge, and that's what I'm saying as an ordinary citizen. What I really wanted to speak to is that somewhere hidden in that question is also a reference to the International Court of Justice. I'm not sure if the question really gets it right. The questions we've been given, it reads, it speaks about the half-hearted commitment of the Security Council's permanent members to the International Court of Justice. I think that is really, in a way, overstating the role of the permanent members of the Security Council, because the fact that they may be permanent members of the Security Council doesn't really say anything specific with respect to their position before the court. Although it must be recognized that out of the P5, only one has accepted the jurisdiction of the International Court of Justice. However, I do think that's the wrong angle of addressing the court's performance. I think that particularly in the past 20, perhaps 30 years, their workload has grown dramatically, and they have done quite a lot, I think, in the sphere of the solution of conflicts that have not reached a hugely politicized level, or conflicts that would not normally end up on the table of the Security Council. So in a way, they're operating in a different field. It is, I think, correct to say that there are issues when the question is very politicized, and that's, I think, is correctly identified as all these advisory opinions. I think that the court has managed to more or less steer clear of major difficulties in these advisory opinions. However, I think it's also a testimony to the inability of the General Assembly to address these issues. I think it is fair to say that a number of these questions probably need not be before the court, but if they're brought before the court, well, the court has to deal with them. But I do think that particularly in the contentious cases, the court has been hugely successful. It is a well-organized court. They're doing a lot of work, perhaps not compared to the numbers of your average domestic court. But at the same time, out of the limelight, they're able to solve lots of issues that could go frightfully wrong, and particularly all these endless series of quite technical boundary issues, where they're doing endless series of boundary issues, really interesting, but at the same time also solving a lot of issues before they go out of control.
Right, and I had actually intended to separate out the ICJ from the original question, but at this point, I'll turn it over to Judge Sepulveda, who wanted to address the ICJ question since it was raised.
Thank you very much. I think the first point has to do with whether or not the Security Council is accountable. If we go back to the 2002 and 12 Declaration on the Rule of Law, you will find that the declaration proclaims that the UN and its principal organs are subject to the rule of law. Now, the problem is whether the Security Council really fulfills the requirements of the rule of law. If we speak of equality, the veto power means that the rule of law would be disregarded by the powers of the Security Council. The other question is the legal constraints that can be imposed on the Security Council. And unfortunately, again, that other principle of the rule of law will not apply in the case of the Security Council. The next issue we will want to examine is whether there is any possibility of submitting the action of a political organ of the UN to the rules, to the jurisdiction of the International Court of Justice. And I think that will not happen. That will not legally happen because there would be very little support for that assumption of jurisdiction on the part of the International Court of Justice. But perhaps what we should do is to distinguish between what the permanent members of the Security Council do and the accountability they may have, and concentrate the attention on what each one of the P5 members can do. How accountable can they be? How responsible can they be before the law? And how obliged are they to comply with the rule of law? And I'm thinking especially in relationship to the decisions, to the judgments of the International Court of Justice. Now, it has already been said that only that only one permanent member of the Security Council has accepted the compulsory jurisdiction of the International Court of Justice. The other 4 members have not. Now, there should be a responsibility in terms of the rule of law for each one of those 4 remaining states accepting the compulsory jurisdiction of the International Court of Justice. One additional issue has to do with the fact that for the last 70 years, the 5 permanent members have had a judge in the International Court of Justice, which doesn't reflect the principle of compulsory jurisdiction of the International Court of Justice. One other issue has to do with compliance with the judgments of the International Court of Justice, which, as a general principle, should be something accepted by states. In one specific case, one permanent of the Security Council has decided not to comply with the judgments of the court in the Avena case and in the Nicaragua case. So that certainly, and I'm responding to the question you put before us, undermines the work of the International Court of Justice, and that I find very unfortunate. Now, on the International Criminal Court, we again have a problem in terms of adherence to the Rome Statute. Unfortunately, again, 3 of the P5 have decided not to subscribe to the Statute of Rome. There, again, there is an action which undermines the legitimacy and the action of an important tribunal dealing with criminal acts. So in spite of all this, the undermining is not, I believe, so fundamental as to essentially affect the work of the International Court of Justice, or for that matter, the ICC. One last point has to do with advisory opinions. I think that the court, the International Court of Justice, in many, many instances has had political disputes before it. Now, the role of the court as a judicial organ has to do with providing legal answers to political issues or to legal issues. It will not matter. And I think that in the case of the International Court of Justice, it has beautifully performed the answers to political questions through legal means. Thank you.
Thank you. Maria, did you want to comment on?
Well, there are so many questions on the table, I don't know where to start from. Well, sorry. Well, let's start from these last comments, and I agree that it is really regretful that not all the permanent members, 5 permanent members, are parties to the ICJ. I won't take up the question of the contentious issues, functions of the court, but the advisory functions. And here I would like to say that out of the 26 cases in which the court gave an advisory opinion, 16 were requested by the General Assembly and only one by the Security Council. And I believe that, and this was in 1970, if I'm right. And I think partly this has to do also with whether the permanent members have accepted or not the compulsory jurisdiction of the court. And of course, this is regrettable because the function of the advisory function of the court is very important in the development of international law. In addition, I think it's regrettable because according to the UN Charter, the court is the principal judicial organ and constitutionally is linked with other organs, the General Assembly and the Security Council. And of course, there are some provisions of the Charter where the Security Council can make recommendations to states to resort to peaceful settlement of disputes, including the judicial means. And again, I don't see how, states which are not, have not accepted the compulsory jurisdiction of the court can really suggest or recommend to states to resort to a peaceful settlement of the issues through the competence of the court. Well, the other issue that I would like to react is about the question of not being members, the P5 to the ICC. Here again, it's very important to note that this could undermine the court, the ICC. And it's obvious because the P5 have the power of referrals and deferrals of cases to the ICC. So you understand that this might give the impression that either by referral or deferral, this is a political tool in the hands of the P5, especially those that haven't accepted the jurisdiction of the ICC. This of course gives this impression, but I disagree that it is the court that should be blamed for that. I mean, whether or not the deferrals or the referrals to the ICC are used in the right way or in the political way by the permanent five, this is not the mistake, this is not the fault of the ICC. We have to separate completely the work of the ICC and its performance, and as Lisbeth said earlier, it is very important. So we have to draw a line between referrals and whether these referrals are being used properly and the performance of the court in the deterrence of crimes against humanity, genocide, and war crimes. And this is a very important role. We should not underestimate what the ICC has done until now. So we have to draw this line. And of course, the main question was about the Charter and what are the fundamental principles within the Charter. And here I agree with you that peace has been evolved. And today, new challenges, and especially terrorism, weapons of mass destruction, and gross violations of human rights are being taken care of by the Security Council, who has interpreted in a very dynamic way, I would say, the provisions of the Charter regarding peace and security. And in many cases, they have assumed power under Chapter 7 in order to confront these new challenges to peace and security, which are different from those in 1945. And still, I mean, we have to commend the Security Council for being able to adjust in these new realities and use the provisions of the Charter in a very constructive way, allowing thus its powers to be exercised under Chapter 7, collective security system, the way they interpret it, of course. And there is room, I think, in the future for the Council to play an important role in other areas, such as poverty, such as the challenges that were mentioned earlier, refugees, displacement, environmental disasters, etc., the way the Security Council interprets the word peace today, it is to be commended. And here I think one can conclude that although the Charter is exactly the same, the UN is not the same today. But yet, the UN is capable of adjusting and of extending its competences in fields, in different fields than the ones that were conceived in 1945 and correspond to new challenges and threats to peace and security, although a lot has to be done yet. Thank you.
So a lot is on the table, and that's partly my fault, but I will now just go around the table for folks to comment on any of the several issues. So Mr. Mohammed, you're first, and then we'll go to Michelle Walker.
Thank you, Chair. I just want to speak on the issue relating to ICC. We know that there are a lot of concerns raised by member states of Asian and African regarding the full implementation of ICC or the Rome Statute. I think one way to look at it is to probably empower regional organizations to look at issues relating to ICC. And we know that, especially in trade matters, regional organization has served its purpose. And we should look at regional organization, therefore, as to whether they have the capacity to implement Rome Statute at their level, especially when the very concern of these countries is in relation to the principle, ensuring that the principle of complementarity being observed. And at many times that we know that the operative word is unless and until the state is unwilling or unable, then the Hague would intervene. But I'm sure in relation to regional organization, the fact that they have this affinity, close affinity and bonding among member states of the region could probably resolve some of the issues which the Hague probably could not settle. One issue that I say this to be quite successful is in relation to R2P. We know that there is a recognition that apart from UN Security Council, the regional organization or international committee can play a role in observing a rule of law at a regional level. So I thought that this is also important. So we should not undermine the importance of regional organization, perhaps empowering regional organization. The other issue is I've taken note of the importance of non-state actors. I think this is also important, that after 300 years of its existence, international law has yet to recognize the contribution of non-state actors, especially the civil societies. So we have only the state and international organization as a legitimate players of international law. Perhaps the coming or the 21st century could look at the status of civil societies. But I'm not saying at the same time they're not accountable. We know that states are grappling at the moment to handle non-state actors at the place that is under very much a place in the Middle East, for example, that we do not know how to handle this entity of non-state actors. They are equally accountable, but we therefore should extend the accountability of international criminal law, not only just to the state or individual, but also non-state actors. So these are my 2 points. Thank you.
Well, I'm glad you raised the regional organizations because we have several cards from the audience raising that. But it's fair to say from the cards, it's not all clear that they think this is a positive thing. So one of the cards was asking whether we have outsourced things to regional organizations, and is that really a good idea? And I think what they probably have in mind is the idea that we would permit regional organizations to respond whether or not they've asked for permission, and including in R2P. But I'll leave that aside. I'm not going to say that everybody's got to discuss regional organizations. Ms. Walker, do you want to address any of the number of issues that have come up?
Well, certainly not regional organizations, although I come from a region with a well-established one, but not for this subject, no. I just wanted to agree on the question of the International Criminal Court, on the ICJ, that it has, in its own quiet way, done a great deal of work over the past at least 20, 30 years in contributing to the rule of law, particularly in one of the most difficult areas, I think, which is boundary disputes. I think one of the speakers made the point that boundaries are thickening, not thinning, and that is true, particularly when those boundaries come with reserves of oil and gas, which is something that can in fact lead to international disputes. And the ICJ has contributed significantly by developing jurisprudence and settling those disputes. So that is an area where they have been quite successful to a certain extent, particularly in my region, where if one looks at the current docket of the court, one will see that we have been generating quite a bit of work for the court on the issue of advisory opinions. The court deals with what's put before it. They're political issues, and they render legal decisions to the best of their ability. So the question becomes, for us as states, what do we send to the court? Why do we send them? And is this the best approach? Again, I think the issue lies within the state's purview, perhaps. Thanks.
You've had your card up for a while, Mr. Ian.
Thank you. Sorry to take the floor again, but just if I could respond briefly on 3 or 4 of these points. First, the ICC, I agree completely with Pablo. I think the ICC is probably the biggest experiment the UN has undertaken and the most complex. Criminal law in a domestic context is a very sophisticated piece of social engineering. In the international context, with the obvious gaps in terms of executive enforcement authority, even a common standard for retribution, reparation, it's clearly an ambitious project. The UK, and I personally, are a huge supporter of the ICC, but no one could say for certain that it will definitely succeed. It's definitely facing challenges, but it's doing very, very well so far. So the ICC. Africa and the ICC, well, there's a huge problem of worldwide legitimacy for the ICC. There's no question about that. And again, the UK policy is firmly to support worldwide membership of the ICC. I think I would say in parenthesis that the fact that states are not willing to sign up to the ICC is again a tribute to the force of the rule of law. They're not willing to be bound by a judicial organ. So that is a tribute to the rule of law, not necessarily a detraction from it.
There's a half full kind of guy.
You've got to look at. It's true though. It's why they don't sign up. As to the African situation, well, there's clearly there are views about these issues, and there are views about the Kenyan situation. But most of the African cases were self-referred. The Kenyan case is far from being one-dimensional, and we should bear that in mind. We should also bear in mind the African Union is not united on the ICC. There's a big division down the African Union as well, and there's not just cases about Africa. There are cases about Palestine, Afghanistan, and Iraq, involving the UK, Ukraine also. So I think this will be a picture that changes. Maybe it started with Africa for lots of reasons. If it had started 20 years earlier, Yugoslavia would have been one of the big cases. So it's an element of how history has worked out. That kind of takes me on to the P5 and judicial control, if I put it that way. I mean, I don't speak for the P5. They're not really a single entity anyway. There's probably far less unites us than divides us than unites us. I mean, compared to the EU, where we are unified on pretty much everything. Even the UK is unified on pretty much everything in the EU. But the P5 is not a unified body, and I'm certainly not speaking for it. Again, in parenthesis, there are 15 members in the Security Council at any one time, not just 5. There are 10 who could do a lot more. really, if they wanted to. So it's not just the P5, although I do accept the position of the P5. For the UK, we have a case in the ICJ at the moment about nuclear disarmament. We have a preliminary examination in the ICC. We've just come out of an arbitration on ITLOS. So I'm tempted to say from that there should perhaps only be one permanent member of the United Nations. I'll leave it.
Yeah, that might create some controversy. Rita?
Thank you. Just quickly also on the ICC and on the need to commend the work that the ICC has done so far, on the difficulty of the work, but also on the importance of having international accountability on crimes against humanity. As to the African situation, the reality of things is that the majority of African cases have been self-referred, as Ian has said, and also at the moment we have the ICC considering other situations, like he said, but also like Georgia and like Ukraine. So we understand that it is sometimes difficult to fully accept the role of the ICC, but our position is that we and the states must work together in order to ensure that the ICC will be able to continue its work and we will be able to see a conclusion of the cases before the ICC. Thank you.
Thank you. Mr. Clavers.
Thank you. Whoa. A footnote on the role of regional organizations. There's, of course, a wonderful scheme in the Charter about the role of regional organizations, but it comes with a drawback. Some organizations think that they have reporting obligations to the UN. So some regional organizations have been reluctant to qualify themselves as regional organizations for purposes of Chapter 8 of the Charter. NATO comes to mind. And that's a distinction to bear in mind when one wants to judge the legitimacy of outsourcing tasks to regional organizations, I guess, whether or not they would accept obligations under the Charter or whether they want to be freelancers.
So I do promise responses. Oh, well, let me raise this one and then we'll turn to this. So this is, I suspect, coming from a student writing a paper to Mr. Nolte. So can subsequent practice modify a constituent instrument of an international organization? A very short answer to that.
Well, I recommend to look at the commentary to draft conclusion 11, which was adopted
Who wrote that again?
year.
Who wrote?
The ILC adopted this. It's a very sensitive topic.
I think that's why it was asked.
We have not really dealt with it because the topic that is being dealt with in the ILC is the interpretation of constituent instruments. Let me say that there are interesting decisions by the International Court of Justice that you can see in one or the other way. Thank you.
Very diplomatic answer, Mr. Talbot. If you would like to answer that question, you can. No, thank you.
Well, my answer is no. In fact, I think we have had these discussions. I just wanted to comment on the ICC discussions. I had thought long and hard about whether I should, and I had decided I wouldn't, but after hearing some of the comments, I thought I just might say a couple of general things. The first thing I want to say is I absolutely agree with the first comment that was made by Pablo about the fact that, you know, when one looks at everything that has happened, very few actors come out with clean hands, and I think that should be the underlying. There is a constant refrain, of course, about how most of the situations are self-referred, but I mean anyone who again looks behind the veil and knows what is really happening, no, that's not really true. That there was a lot of pressure on these states, and in fact the reward for the self-referrals is that, well, we go after your enemies. I mean, look at all of these cases of self-referrals, and there's a conflict in the DRC. Oh, but only one side in the conflict has committed crimes. The government hasn't. The government has clean hands. I mean, I think that tells you a little bit something about these self-referrals. The question is, the question that most critics are asking is, well, what about Palestine, which has been under consideration since 2008, and then it was stopped in 2012, 2013. It was started again, but never an investigation. I mean, that's a critical question to ask. What about Afghanistan, that has been under analysis since 2007? You ask the prosecutor, well, why aren't you making a decision on this? Oh, because it's too complex, the conflict is still ongoing. Yeah, I mean, there was a conflict ongoing in Libya and the decision was made within weeks. And I'm not saying, and anyone who has read anything I've written on this issue will know that this is a constant theme, that all of the criticism that are thrown at the other side are overly simplistic. I mean, I'm not saying, for example, that the African Union comes with clean hands, and I can give an example of that. The African Union complains that our request for an Article 16 deferral hasn't been complied with, so we're going to take measures, and those measures aren't directed at the entity where the request was made. It's directed at the ICC. So all I'm saying is that, I mean, I've heard all of these arguments back and forth, and the reality is a little more complex than what we say. I mean, it's easy in diplomacy to stand up at the podium and say, you know, I mean, the statistics will show that most of the situations have been referred. You have to make a distinction between the Security Council and the ICC. Yeah, but we know that there's a lot more going on than what's in the surface, and it's a little more complicated. I just thought I should make that point. And then one other point that I will make, which is kind of counterintuitive. I also think it's a little unfair to sort of criticize the P5 or the P4, I guess, because UK, for not
you criticize the P4 if you like.
Yeah, not accepting the compulsory jurisdiction of the ICJ. I think it's a responsibility, and it's not a legal responsibility, of all states, and it's not just the P4. So to the extent that we want to make that criticism should be directed at everyone. Similarly, with respect to the fact that the Security Council can refer and defer, I mean, I think it's very unfortunate, but you can't blame the P5 for that. States negotiated the wrong statute. I mean, everybody who negotiated that statute has to take responsibility, and I think it's totally unfair to point the finger at the P3, P2, whatever, at the P5, even at the Security Council. I mean, the finger should be pointed at those who negotiated the statute, and that's everyone. Thanks.
So we're at almost the very end, but there was one last question that drew some considerable interest around this table, so I want to toss it out, and that's the SDGs. Considerable attention has been paid to them as social goals, but are there legal tools to achieve the SDGs that should be on the table, that haven't been put on the table, that anyone around the table wants to propose? In particular, there is, I'll remind you, the rule of law is mentioned in Target 16.3, promote the rule of law at the national and international levels and ensure equal access to justice. And that question, has the UN been successful, either at the national or international level on that so far? But I just want to toss out the SDG question to see if anyone wants to bite, and I guess Pablo has.
And here, what I would like to say is an invitation to self-reflection to people that do human rights and law in general. The Millennium Declaration that was the preface to the MDGs is a wonderful document which includes all sorts of references to justice and to human rights. And really it is worth reading because all of its persuasive powers, I think, remains. The MDGs are well known for not having included any reference to justice or to human rights. And the question is why? And one can say all sorts of things about the success and failure of the MDGs, but that they mobilized resources in favor of the areas that were included, and that they provided leverage, both nationally and internationally, for action in those areas. I don't think that should be disputed. Now, the reason why, in my opinion, the reason why this was never included has a lot to do with our inability to be willing to engage in discussions about implementation, success, indicators, and goals. The human rights community, and I am a member of this, of course, is notoriously weak in its ability to participate in discussions of this sort. And I don't know whether it's a confusion between justification and implementation, that we think that the purity of our motives create an exemption from the need to talk about effectiveness. But the fact is that we self-excluded ourselves from the previous development goals. We made it on a shoestring into these ones. But of course, the fact that we are in 16.3 doesn't guarantee that anything will happen. It's now our turn to take part in a serious discussion about how to go from end states, which we are brilliant at describing, from norms into policies. And that means things that can be budgeted, that can be implemented, and that can be monitored. And we have to leave a bit of our squeamishness aside if that's going to happen. The healthcare and the education sectors, for example, of course could have said, oh, it's a gross simplification of both health and education to simply use as proxies number of children vaccinated, decreases in maternal mortality rates, and increases in the number of people enrolled, of children enrolled in primary education. But they understood that these were proxies, that these were gateways into a conversation that was very important for both health and education. We, by contrast, 15 years ago said, no one can measure justice. This is impossible to do, and therefore we do not participate in the conversation. I hope that we are smarter this time around, because otherwise, once again, we will exclude justice and human rights from an otherwise increasing consensus about a rich notion of peace and security that includes justice and human rights. But now I think it's a lot our turn to provide viable responses to how these things can be implemented.
Well, thank you. Any other last remarks? Well, I guess everyone around the table is exhausted, but we do have a reward. But it is a little depressing to end on the note that maybe lawyers are math phobic, which I think that's what you're suggesting. But I think we actually are. But thank you all. Oh, Mr. Do you mind if I have a comment as well? Yes, please.
I think it's appropriate to speak about what is our role as international lawyers. And picking up on your comment, but also Professor Mohamed, my colleague Rita, on capacity, it's not only a problem of capacity, it's also up to us to put law and international law in the center of the political and diplomatic process. And I wanted to tell you that I don't do secret deals with some member states. But I'm often very interested to know what member states think of a particular issue. I reach out for member states sometimes, and sometimes member states reach out for me, but very few of them, and my door is open. You understand the message? Now, on the capacity, yes, some of us, and I'm coming from a country with limited capacities, but I had to struggle with my colleagues in the Ministry of Foreign Affairs because I've done the job you do. I have to strive to have a place for legal considerations in the political process. And I'm sure many of you have this problem as well. It's up to us to take the challenge and not to accept in a passive way the argument of lack of capacities. Also, and I wanted to, I mean, I don't want to be unpleasant, but what I see, for instance, is a very limited level of commitment of some members of the International Law Commission, which is an organ which is diverse in its geographical constitution. And we pay for the expenses in Geneva, so there's no, I mean, the UN pay, you pay member states. So, you know, some of these aspects we have to be careful. And they don't apply universally. I have been recently observing an enormous interest by China in anything related to international law. So maybe things are changing. I have some difficulty in accepting that international law is a product of the West to the West. It doesn't have to be like that. But it's up to states to take the responsibility to change that perception. Thank you. And thank you, Professor Alvarez, for this excellent panel of very distinguished speakers. I got some ideas for the future. Thank you very much.
So,